Hey everybody and welcome back. In our attempt to bring you the best legal minds in the country, we have another video in our series with Professor Baxi. Professor Baxi is a Padma Shri awardee. He was the Vice Chancellor of Delhi University, is a professor at some of the most prestigious universities, and most importantly is a doyen of jurisprudence. And we are asking him questions on topics of jurisprudence that are most commonly asked in competitive exams and something that you can easily plug into your essay or your interview. We are not covering the entire jurisprudence course with him. We are just talking to him on the most commonly asked questions and topics. So if you get a question on it, or if you mention it in your interview or in your essay somewhere that you learned this from Professor Baxi, who is Padma Shri and a doyen of jurisprudence, it adds to your credibility and it makes you stand out from the sea of other aspirants. So do yourself a favor and learn from a legal luminary who is the brightest and the best in the field. We have done a video with him on Grundnorm, and today we are doing a video with him on Volksgeist, which is another commonly asked question. So without any further delay, let's get into the video. In our today's video, we asked him about Volksgeist, its concept and its Indian application. Where can we find examples of Volksgeist in India? Is there something in Indian law that is of a similar concept? So without any delay, let's get into the video and let's hear from Professor Baxi on what does Volksgeist mean and its Indian application.
Volksgeist. The Volksgeist is attributed to, rightly so, to a man called Friedrich von Sabine, the German jurist in the 19th century. And he invented this concept of, or in English you can, Volk means people, Geist means spirit, the spirit of the people. So he said law rests on the spirit of the people. And he had a particular context in mind. Sabine was worried about, and it was great controversy with another jurist called Thibaut. Thibaut proposed codification of Roman law. Codified Roman law should prevail. And Sabine said, look, you can't codify Roman law because most of the Germanic tribes then did not know Roman law. It was not their law, the alien law. So he said for a codification to succeed, two conditions were necessary. One was a technical condition, and that is where people at least ought to know the law. Everybody should know the law. Now take Article 44 of the Indian Constitution, which is a uniform civil code. Very few people know the law of the bills or the nagas. Customary law systems are not known. In the north we don't know, we say Khap Panchayat is bad. Of course it is bad in some respects, but Khap Panchayat, people say we exist through history and we have our own customary law. So customary systems of law are virtually unknown. How can you have uniform civil code when you don't have the technical element? When you don't have that technical element, where people don't know the law, how can you make a code? So Sabine always emphasized the technical element, and the other element he called Volksgeist, political element. The political will there must be. And political will is a function of people's consciousness of people, spirit of the people. How do you look at that? We can translate in modern times in this way. We can translate it as social inheritance of laws. The Constitution is socially inherited now. So it, in a sense, the spirit of the Constitution is the spirit of the people. One answer to that. Indian context, for example, I just now said, as I said just now, it means the Constitution as interpreted. If you take the third schedule of the Indian Constitution, which concerns the oath of office. All ministers have to undertake, all chief ministers, governors, judges. The oath has been the Constitution as amended now by 42nd Amendment is Constitution as by law established. As by law established, Article 141 of the Constitution said the law declared by the Supreme Court shall be binding on all courts subject, not everybody, you and me, but everybody, but the all courts, but indirectly is binding on all. So there is a system which we call the Constitution, and it embodies the spirit of the people. For example, Parliament, when it legislates, or state legislature will legislate, always justify the power not only by the Constitution but by the spirit of the people. Similarly, judges, judicial review is justified ultimately by the confidence people have in courts. So law is in a sense, comes from the people and goes to the people, both ways. In a sense, this is the thesis of Volksgeist that prevails.